3201. Confession of judgment before default on certain installment contracts invalid. Notwithstanding the provisions of Section 3218, no judgment by confession shall be entered on any affidavit which was executed prior to the time a default in the payment of an installment occurs in connection with the purchase for $1,500 or less of any commodities for any use, other than a commercial or business use upon any plan of deferred payments whereby the price or cost is payable in 2 or more installments. Any judgment entered in violation of this section is void and unenforceable. 3211. Motion to dismiss. Motion to dismiss cause of action. A party may move for judgment dismissing one or more causes of action asserted against him on the ground that 1. A defense is founded upon documentary evidence, or 2. The court has not jurisdiction of the subject matter of the cause of action, or 3. The party asserting the cause of action has not legal capacity to sue, or 4. There is another action pending between the same parties for the same cause of action in a court of any state or the United States. The court need not dismiss upon this ground but may make such order as justice requires. Or 5. The cause of action may not be maintained because of arbitration and award, collateral estoppel, discharge in bankruptcy, infancy or other disability of the moving party, payment, release, res judicata, statute of limitations, or statute of frauds, or 6. With respect to a counterclaim, it may not properly be interposed in the action, or 7. The pleading fails to state a cause of action, or 8. The court has not jurisdiction of the person of the defendant, or 9. The court has not jurisdiction in an action where service was made under Section 314 or 315, or 10. The court should not proceed in the absence of a person who should be a party. 11. The party is immune from liability pursuant to Section 720A of the Not-for-Profit Corporation Law. Presumptive evidence of the status of the corporation, association, organization or trust under Section 501, c. 3, of the Internal Revenue Code may consist of production of a letter from the United States Internal Revenue Service reciting such determination on a preliminary or final basis, or production of an official publication of the Internal Revenue Service, listing the corporation, association, organization or trust as an organization described in such section, and presumptive evidence of uncompensated status of the defendant may consist of an affidavit of the chief financial officer of the corporation, association, organization or trust. On a motion by a defendant based upon this paragraph, the court shall determine whether such defendant is entitled to the benefit of Section 720A of the Not-for-Profit Corporation Law or Subdivision 6 of Section 20.09 of the Arts and Cultural Affairs Law, and, if it so finds, whether there is a reasonable probability that the specific conduct of such defendant alleged constitutes gross negligence or was intended to cause the resulting harm. If the court finds that the defendant is entitled to the benefits of that section and does not find reasonable probability of gross negligence or intentional harm, it shall dismiss the cause of action as to such defendant. B. Motion to dismiss defense. A party may move for judgment dismissing one or more defenses, on the ground that a defense is not stated or has no merit. C. Evidence permitted. Immediate trial. Motion treated as one for summary judgment. Upon the hearing of a motion made under subdivision A or B, either party may submit any evidence that could properly be considered on a motion for summary judgment, whether or not issue has been joined. The court, after adequate notice to the parties, may treat the motion as a motion for summary judgment. The court may, when appropriate for the expeditious disposition of the controversy, order immediate trial of the issues raised on the motion. D. Facts unavailable to opposing party, should it appear from affidavits submitted in opposition to a motion made under subdivision A or B, that facts essential to justify opposition may exist but cannot then be stated, the court may deny the motion, allowing the moving party to assert the objection in his responsive pleading, if any, or may order a continuance to permit further affidavits to be obtained or disclosure to be had, and may make such other order as may be just. B. Number, time and waiver of objections. Motion to plead over. At any time before service of the responsive pleading is required, a party may move on one or more of the grounds set forth in subdivision A, and no more than one such motion shall be permitted. Any objection or defense based upon a ground set forth in paragraphs 1, 3, 4. 115. Default judgment. Default and entry. When a defendant has failed to appear, plead or proceed to trial of an action reached and called for trial, or when the court orders a dismissal for any other neglect to proceed, the plaintiff may seek a default judgment against him. If the plaintiff's claim is for a sum certain or for a sum which can by computation be made certain, Application may be made to the clerk within 1 year after the default. The clerk, upon submission of the requisite proof, shall enter judgment for the amount demanded in the complaint or stated in the notice served pursuant to subdivision B of Rule 305, plus costs and interest. Upon entering a judgment against less than all defendants, the clerk shall also enter an order severing the action as to them. When a plaintiff has failed to proceed to trial of an action reached and called for trial, or when the court orders a dismissal for any other neglect to proceed, the defendant may make application to the clerk within 1 year after the default, and the clerk, upon submission of the requisite proof, shall enter judgment for costs. Where the case is not one in which the clerk can enter judgment, the plaintiff shall apply to the court for judgment. B. Procedure before court. The court, with or without a jury, may make an assessment or take an account or proof, or may direct a reference. When a reference is directed, the court may direct that the report be returned to it for further action or, except where otherwise prescribed by law, that judgment be entered by the clerk in accordance with the report without any further application, except in a matrimonial action. No finding of fact in writing shall be necessary to the entry of a judgment on default. The judgment shall not exceed in amount or differ in type from that demanded in the complaint or stated in the notice served pursuant to subdivision B of Rule 305. C. Default not entered within 1 year. If the plaintiff fails to take proceedings for the entry of judgment within 1 year after the default, the court shall not enter judgment but shall dismiss the complaint as abandoned, without costs, upon its own initiative or on motion, unless sufficient cause is shown why the complaint should not be dismissed. A motion by the defendant under this subdivision does not constitute an appearance in the action. D. Multiple defendants. Whenever a defendant has answered and one or more other defendants have failed to appear, plead, or proceed to trial of an action reached and called for trial, notwithstanding the provisions of subdivision C of this section, upon application to the court within 1 year after the default of any such defendant, the court may enter an ex parte order directing that proceedings for the entry of a judgment or the making of an assessment, the taking of an account or proof, or the direction of a reference be conducted at the time of or following the trial or other disposition of the action against the defendant who has answered. Such order shall be served on the defaulting defendant in such manner as shall be directed by the court. B. Place of application to court. An application to the court under this section may be made, except where otherwise prescribed by rules of the chief administrator of the courts, by motion at any trial term in which the action is triable or at any special term in which a motion in the action could be made. Any reference shall be had in the county in which the action is triable, unless the court orders otherwise. F. Proof. On any application for judgment by default, the applicant shall file proof of service of the summons and the complaint, or a summons and notice served pursuant to subdivision B of Rule 305 or subdivision A of Rule 316 of this chapter, and proof of the facts constituting the claim, the default and the amount due by affidavit made by the party, or where the state of New York is the plaintiff, by affidavit made by an attorney from the office of the Attorney General who has or obtains knowledge of such facts through review of state records or otherwise. Where a verified complaint has been served, it may be used as the affidavit of the facts constituting the claim and the amount due. In such case, an affidavit as to the default shall be made by the party or the party's attorney. When jurisdiction is based on an attachment of property, the affidavit must state that an order of attachment granted in the action has been levied on the property of the defendant, describe the property and state its value. Proof of mailing the notice required by subdivision G of this section, where applicable, shall also be filed. G. Notice 1. Except as otherwise provided with respect to specific actions, whenever application is made to the court or to the clerk, any defendant who has appeared is entitled to at least 5 days' notice of the time and place of the application, and if more than 1 year has elapsed since the default, any defendant who has not appeared is entitled to the same notice unless the court orders otherwise. The court may dispense with the requirement of notice when a defendant who has appeared has failed to proceed to trial of an action reached and called for trial too, where an application for judgment must be made to the court. The defendant who has failed to appear may serve on the plaintiff at any time before the motion for judgment is heard a written demand for notice of any reference or assessment by a jury which may be granted on the motion. Such a demand does not constitute an appearance in the action. Thereupon at least 5 days' notice of the time and place of the reference or assessment by a jury shall be given to the defendant by service on the person whose name is subscribed to the demand, in the manner prescribed for service of papers generally 3. I. When a default judgment based upon non-appearance is sought against a natural person in an action based upon non-payment of a contractual obligation, an affidavit shall be submitted that additional notice has been given by or on behalf of the plaintiff at least 20 days before the entry of such judgment, by mailing a copy of the summons by first class mail to the defendant at his place of residence in an envelope bearing the legend personal and confidential and not indicating on the outside of the envelope that the communication is from an attorney or concerns an alleged debt. In the event such mailing is returned as undeliverable by the post office before the entry of a default judgment, or if the place of residence of the defendant is unknown, a copy of the summons shall then be mailed in the same manner to the defendant at the defendant's place of employment if known. If neither the place of residence nor the place of employment of the defendant is known, then the mailing shall be to the defendant at his last known residence. II. The additional notice may be mailed simultaneously with or after service of the summons on the defendant. An affidavit of mailing pursuant to this paragraph shall be executed by the person mailing the notice and shall be filed with the judgment, where there has been compliance with the requirements of this paragraph. Failure of the defendant to receive the additional notice shall not preclude the entry of default judgment. II. This requirement shall not apply to cases in the small claims part of any court, or to any summary proceeding to recover possession of real property, or to actions affecting title to real property, except residential mortgage foreclosure actions for I. When a default judgment based upon non-appearance is sought against a domestic or authorized foreign corporation which has been served pursuant to paragraph B of Section 306 of the Business Corporation Law, an affidavit shall be submitted that an additional service of the summons by first-class mail has been made upon the defendant corporation at its last known address at least 20 days before the entry of judgment. II. The additional service of the summons by mail may be made simultaneously with or after the service of the summons on the defendant corporation pursuant to paragraph B of Section 306 of the Business Corporation Law, and shall be accompanied by a notice to the corporation that service is being made or has been made pursuant to that provision. An affidavit of mailing pursuant to this paragraph shall be executed by the person mailing the summons and shall be filed with the judgment, where there has been compliance with the requirements of this paragraph. Failure of the defendant corporation to receive the additional service of summons and notice provided for by this paragraph shall not preclude the entry of default judgment. III. This requirement shall not apply to cases in the small claims part or commercial claims part of any court, or to any summary proceeding to recover possession of real property, or to actions affecting title to real property. H. Judgment for excess where counterclaim interposed, in an action upon a contract where the complaint demands judgment for a sum of money only, if the answer does not deny the plaintiff's claim but sets up a counterclaim demanding an amount less than the plaintiff's claim. The plaintiff upon filing with the clerk an admission of the counterclaim may take judgment for the excess as upon a default. I. Default judgment for failure to comply with stipulation of settlement 1, where, after commencement of an action, a stipulation of settlement is made, providing, in the event of failure to comply with the stipulation, for entry without further notice of a judgment in a specified amount with interest, if any, from a date certain, the clerk shall enter judgment on the stipulation and an affidavit as to the failure to comply with the terms thereof, together with a complaint or a concise statement of the facts on which the claim was based to, where, after commencement of an action, a stipulation of settlement is made, providing, in the event of failure to comply with the stipulation, for entry without further notice of a judgment dismissing the action, the clerk shall enter judgment on the stipulation and an affidavit as to the failure to comply with the terms thereof, together with the pleadings or a concise statement of the facts on which the claim and the defense were based. Rule 3216. Want of prosecution. Where a party unreasonably neglects to proceed generally in an action or otherwise delays in the prosecution thereof against any party who may be liable to a separate judgment, or unreasonably fails to serve and file a note of issue, the court, on its own initiative or upon motion, with notice to the parties, may dismiss the parties pleading on terms, unless the order specifies otherwise. The dismissal is not on the merits. B. No dismissal shall be directed under any portion of subdivision of this rule, and no court initiative shall be taken or motion made thereunder unless the following conditions precedent have been complied with. 1. Issue must have been joined in the action. 2. 1 year must have elapsed since the joinder of issue, or 6 months must have elapsed since the issuance of the preliminary court conference order where such an order has been issued, whichever is later. 3. The court or party seeking such relief, as the case may be, shall have served a written demand by registered or certified mail requiring the party against whom such relief is sought to resume prosecution of the action and to serve and file a note of issue within 90 days after receipt of such demand, and further stating that the default by the party upon whom such notice is served in complying with such demand within said 90-day period will serve as a basis for a motion by the party serving said demand for dismissal as against him or her, for unreasonably neglecting to proceed. Where the written demand is served by the court, the demand shall set forth the specific conduct constituting the neglect, which conduct shall demonstrate a general pattern of delay in proceeding with the litigation. C. In the event that the party upon whom is served the demand specified in subdivision B. 3 of this rule serves and files a note of issue within such 90-day period, the same shall be deemed sufficient compliance with such demand and diligent prosecution of the action, and in such event, no such court initiative shall be taken and no such motion shall be made, and if taken or made, the court initiative or motion to dismiss shall be denied. D. After an action has been placed on the calendar by the service and filing of a note of issue, with or without any such demand, provided, however, if such demand has been served, within the said 90-day period, the action may not be dismissed by reason of any neglect, failure or delay in prosecution of the action prior to the said service and filing of such note of issue. B. In the event that the party upon whom is served the demand specified in subdivision B. 3 of this rule fails to serve and file a note of issue within such 90-day period, the court may take such initiative or grant such motion unless the said party shows justifiable excuse for the delay and a good and meritorious cause of action. F. The provisions of this rule shall not apply to proceedings within Rule 30. 404.
So let's go to 3404 to see what that is.
Rule 3404. Dismissal of abandoned cases. A case in the Supreme Court or a county court marked off or struck from the calendar or unanswered on a clerk's calendar call, and not restored within 1 year thereafter, shall be deemed abandoned and shall be dismissed without costs for neglect to prosecute. The clerk shall make an appropriate entry without the necessity of an order. Rule 3217. Voluntary discontinuance. Without an order, any party asserting a claim may discontinue it without an order. 1. By serving upon all parties to the action a notice of discontinuance at any time before a responsive pleading is served, or, if no responsive pleading is required, within 20 days after service of the pleading asserting the claim and filing the notice with proof of service with the clerk of the court. Or 2. By filing with the clerk of the court before the case has been submitted to the court or jury a stipulation in writing signed by the attorneys of record for all parties, provided that no party is an infant, incompetent person for whom a committee has been appointed or conservatee, and no person not a party has an interest in the subject matter of the action. Or 3. By filing with the clerk of the court before the case has been submitted to the court or jury a certificate or notice of discontinuance stating that any parcel of land which is the subject matter of the action is to be excluded pursuant to Title 3 of Article 11 of the Real Property Tax Law. B. By order of court, except as provided in subdivision an action shall not be discontinued by a party asserting a claim except upon order of the court and upon terms and conditions, as the court deems proper. After the cause has been submitted to the court or jury to determine the facts, the court may not order an action discontinued except upon the stipulation of all parties appearing in the action. C. Effect of discontinuance. Unless otherwise stated in the notice, stipulation or order of discontinuance, the discontinuance is without prejudice, except that a discontinuance by means of notice operates as an adjudication on the merits if the party has once before discontinued by any method an action based on or including the same cause of action in a court of any state or the United States. D. All notices, stipulations, or certificates pursuant to this rule shall be filed with the county clerk by the defendant. Judgment by confession. Affidavit of defendant. Except as provided in Section 3201, a judgment by confession may be entered, without an action, either for money due or to become due, or to secure the plaintiff against a contingent liability in behalf of the defendant, or both. upon an affidavit executed by the defendant, 1 stating the sum for which judgment may be entered, authorizing the entry of judgment, and stating the county where the defendant resides or if he is a non-resident, the county in which entry is authorized. 2. If the judgment to be confessed is for money due or to become due, stating concisely the facts out of which the debt arose and showing that the sum confessed is justly due or to become due. And 3. If the judgment to be confessed is for the purpose of securing the plaintiff against a contingent liability, stating concisely the facts constituting the liability and showing that the sum confessed does not exceed the amount of the liability. B. Entry of judgment. At any time within 3 years after the affidavit is executed, it may be filed with the clerk of the county where the defendant stated in his affidavit that he resided when it was executed, or, if the defendant was then a non-resident, with the clerk of the county designated in the affidavit. Thereupon the clerk shall enter a judgment in the Supreme Court for the sum confessed. He shall tax costs to the amount of $15, besides disbursements taxable in an action. The judgment may be docketed and enforced in the same manner and with the same effect as a judgment in an action in the Supreme Court. No judgment by confession may be entered after the defendant's death. C. Execution where the judgment is not all due. Where the debt for which the judgment is entered is not all due, execution may be issued only for the sum which has become due. The execution shall be in the form prescribed for an execution upon a judgment for the full amount recovered, except that it shall direct the sheriff to collect only the sum due, stating the amount with interest and the costs of the judgment. Notwithstanding the issuance and collection of such an execution, the judgment shall remain in force as security for the sum or sums to become due after the execution is issued. When further sums become due, further executions may be issued in the same manner. D. Confession by joint debtors. 1 or more joint debtors may confess a judgment for a joint debt due or to become due. Where all the joint debtors do not unite in the confession, the judgment shall be entered and enforced against only those who confessed it, and it is not a bar to an action against the other joint debtors upon the same demand. Rule 3219. Tender. At any time not later than 10 days before trial, any party against whom a cause of action based upon contract, expressed or implied, is asserted, and against whom a separate judgment may be taken, may, without court order, deposit with the clerk of the court for safekeeping an amount deemed by him to be sufficient to satisfy the claim asserted against him, and serve upon the claimant a written tender of payment to satisfy such claim. A copy of the written tender shall be filed with the clerk of the money is so deposited. The clerk shall place money so received in the safe or vault of the court to be provided for the safekeeping thereof. They're to be kept by him until withdrawal by claimant or return to the depositor or payment thereof to the county treasurer or commissioner of finance of the city of New York, as hereinafter provided. Within 10 days after such deposit the claimant may withdraw the amount deposited upon filing a duly acknowledged statement that the withdrawal is in satisfaction of the claim. The clerk shall thereupon enter judgment dismissing the pleading setting forth the claim, without costs. Where there is no withdrawal within such 10-day period, the amount deposited shall, upon request, be repaid to the party who deposited it. If the tender is not accepted and the claimant fails to obtain a more favorable judgment, he shall not recover interest or costs from the time of the offer, but shall pay costs for defending against the claim from that time. A tender shall not be made known to the jury. Money received by the clerk of the court for safekeeping as hereinabove provided and later withdrawn by claimant or repaid to the depositor pursuant to the provisions hereof shall not be deemed paid into court, if the deposit is neither withdrawn by claimant nor returned to the depositor upon his request at the expiration of the 10-day period. The amount of such deposit shall be deemed paid into court as of the day following the expiration of the 10-day period, and the clerk shall pay the amount of the deposit to the county treasurer or commissioner of finance of the city of New York, in accordance with section 2601 of the Civil Practice Law and Rules. Withdrawal of such amount thereafter shall be in accordance with the provisions of Rule 2607. Fees for services rendered therein by a county treasurer or the commissioner of finance of the city of New York are set forth in section 8010. Rule 3220. Offer to liquidate damages conditionally. At any time not later than 10 days before trial, any party against whom a cause of action based upon contract, express or implied, is asserted may serve upon the claimant a written offer to allow judgment to be taken against him for a sum therein specified, with costs then accrued, if the party against whom the claim is asserted fails in his defense. If within 10 days thereafter the claimant serves a written notice that he accepts the offer, and damages are awarded to him on the trial, they shall be assessed in the sum specified in the offer. If the offer is not so accepted and the claimant fails to obtain a more favorable judgment, he shall pay the expenses necessarily incurred by the party against whom the claim is asserted, for trying the issue of damages from the time of the offer. The expenses shall be ascertained by the judge or referee before whom the case is tried. An offer under this rule shall not be made known to the jury. Rule 3221. Offer to compromise. Except in a matrimonial action, at any time not later than 10 days before trial, any party against whom a claim is asserted, and against whom a separate judgment may be taken, may serve upon the claimant a written offer to allow judgment to be taken against him for a sum or property or to the effect therein specified, with costs then accrued. If within 10 days thereafter the claimant serves a written notice that he accepts the offer, either party may file the summons, complaint and offer, with proof of acceptance, and thereupon the clerk shall enter judgment accordingly. If the offer is not accepted and the claimant fails to obtain a more favorable judgment, he shall not recover costs from the time of the offer, but shall pay costs from that time. An offer of judgment shall not be made known to the jury.
Fucking read this.
Rule 3222. Action on submitted facts. Commencement. An action, except a matrimonial action, may be commenced by filing with the clerk a submission of the controversy, acknowledged by all parties in the form required to entitle a deed to be recorded. The submission shall consist of a case, containing a statement of the facts upon which the controversy depends, and a statement that the controversy is real and that the submission is made in good faith for the purpose of determining the rights of the parties. If made to the Supreme Court, the submission shall specify the particular county clerk with whom the papers are to be filed. B. Subsequent proceedings. Subsequent proceedings shall be had according to the civil practice law and rules except that 1. An order of attachment or a preliminary injunction shall not be granted. 2. The controversy shall be determined on the case alone. 3. If the submission is made to the Supreme Court, it shall be heard and determined either by the court, or by the appellate division, or, with his consent, by a specified judge or referee, as the parties may stipulate. 4. On such a submission the court, judge or referee may find facts by inference from the facts stipulated. And 5. If the statement of facts in the case is not sufficient to enable the court to enter judgment, the submission shall be dismissed or the court shall allow the filing of an additional statement.